Well, hey, everybody. Welcome to our March 2024 Abbeville Institute Zoom webinar. We're doing something that we haven't done in a couple of years, where we have more than one participant in these webinars. And of course, we're doing this in the daytime as well, which is a little bit unusual. Usually do these at night, but we thought it'd be a lot of fun to have a conference or a webinar on the 14th Amendment, which is such a big topic. Whether you're on the left, on the right, it's something that people are wrestling with on a regular basis. We just saw it in the news because of the Trump v. Anderson case in Colorado, which is something entirely different from what we're going to get to today, probably, but we might be able to talk about that a little bit too. So this is a big current topic, and it's always current if you're talking about the Supreme Court, because in some ways the 14th Amendment has become the United States Constitution. So I thought it would be a good idea to have some excellent legal scholars come on and talk about the 14th Amendment, its original intent, and of course, related to that, Raoul Berger, who wrote an excellent book, actually two excellent books, on the 14th Amendment and its original meaning. We also had another book come out a couple of years ago, Randy Barnett's The Original Meaning of the 14th Amendment, which would contradict just about everything we're going to say today. So there's certainly several different interpretations of this amendment, and we have people on the Supreme Court like Justice Jackson Brown, who says she is a 14th Amendment originalist. So this is, again, a really big topic that people need to understand. So we have, again, three great legal scholars today, and I'm going to introduce them all to you. The first is Alan Mendenhall. He has a PhD from Auburn University and a JD from West Virginia University School of Law. He's also the Associate Dean and Grady Rosier Professor in the Sorrell College of Business at Troy University and the Director of the Manuel H. Johnson Center for Political Economy. He has spoken to the Abbeville Institute before. He is an excellent scholar, and we're really pleased to have him. Bill Watkins is a research fellow at the Independent Institute. He's the author of the book Crossroads for Liberty, and he received a BA in history and a German summa cum laude from Clemson University. Unfortunately, he went to Clemson. We'll forgive that. But he also went to University of South Carolina School of Law, so that's okay. And we have Jesse Meriam, who has a PhD in political science and an MA in philosophy from Johns Hopkins and a JD from George Washington University School of Law. He's also an associate professor of government and pre-law at Patrick Henry College in Virginia. So all of these men have spoken to the Institute before in one way or another. We just had Bill out at our Callaway Gardens conference this past month. And of course, Jesse's been on a webinar with us. Alan spoke to us, I guess it was in Texas a few years back. We did a conference in Texas, and he was out there for that. So it's a lot of fun to have them all back on with us. And again, remember, all these things are free of charge to you, but not to us. So if you do like the Institute and you want to help us, you can make a tax-deductible donation to the Institute, and we do appreciate all of your support. So we're going to go, each speaker is going to have about 20 to 30 minutes. We're going to start with Alan Mendenhall. After every speaker has completed their presentation, I'll make some comments and we'll have a discussion, and then you can ask questions. So you can use the Q&A button down below. You can use the chat, which I will turn on. I'm sorry it's not on yet, but we will get that going. So you can use the chat or the Q&A button to make questions or ask questions to the panelists and to myself. So without further ado, let's turn it over to Alan.
Well, thank you, Brian. Thank you for the invitation to be here. It's been about a decade since I was active in these conversations about the 14th Amendment, and I welcome the opportunity to jump back into them. I want to start by saying just a few words about Raoul Berger. He was born in Russia. He grew up in a family of modest means that immigrated to the United States. He began his career as a violinist and only graduated from law school at age 35. He went to Northwestern for law school. He entered government practice, went right out of law school because as a Jewish man, he found it difficult to be hired by private law firms. And then he taught at Berkeley, he taught at Harvard, but he was no conservative. He was not a traditionalist. He was not a libertarian, as you could probably discern from reading the book. He uses the term libertarian as a pejorative, but he was mostly a moderate Democrat and an expositor of judicial restraint and one of the early proponents of originalism, which had not fully formed into the version that we have with us today. Nevertheless, he became a hero to conservatives who were upset with the trajectory set by the Warren Court. that expanded the role of the judiciary beyond the scope that any previous generation of Americans could have envisioned. There's a great Liberty Fund documentary about his life called Profile in Liberty, and it's about an hour long. I would highly recommend it. But this book, Government by the Judiciary, the version I'm using is the Liberty Fund edition published in 1997. The first edition was 1997. The first version was 1977. So about 47 years ago. And according to Forrest McDonald, who wrote the introduction to this Liberty Fund version, this edition is the original version, liberally sprinkled with fresh addenda. He actually spent 18 years responding to his critics, incorporating new arguments into this latter edition. One thing I noticed right off the bat when I was rereading this book is that he favors the term original intention because he was writing before the evolution of originalism into the original public meaning, which focuses on the prevailing understanding of words by an informed general reader at the time those words were employed. So the rejection of current originalism is of the subjective intent of the drafters, because of course a legislative body has no single intent. Legislation, or in the case of an amendment to the Constitution, comes about through compromise and deliberation and does not represent one single view. So originalism has moved away from this focus on intent and now focuses on original public meaning. But Berger says that it's the thesis of this book that the Supreme Court is not empowered to rewrite the Constitution, that in its transformation of the 14th Amendment, it has demonstrably done so. Berger's position is that the framers of the 14th Amendment had limited rather than expansive objectives. Now, the 150th anniversary of this amendment in 2018, there was a panel at the National Constitution Center at which all the panelists seemed to celebrate the drafters, the framers of this amendment. And there were really no naysayers to the view that what the 39th Congress had done was exceptional here. Raoul Berger takes a very different approach and sort of slaughters sacred cows, as it were. He says that the key to understanding the Fourth Amendment is that the North was shot through with Negrophobia, that the Republicans, except for a minority of extremists, were swayed by the racism that gripped their constituents rather than by abolitionist ideology. He found that the North was fanatically racist and terrified of emancipated slaves who migrated north. Of the Republicans, he said, not civil rights for blacks, but the dreaded takeover of the federal government by the South was their obsessive preoccupation. Well, why was this? It was because the 13th Amendment eliminated the 3/5 clause. So once freed slaves became citizens, the population of the South expanded dramatically. And this was terrifying to the Northern politicians who were afraid of Southerners gaining representation in Congress. One other key to understanding Raoul Berger's jurisprudence in this regard is that he believed that the Bill of Rights exists to limit and not expand federal power. Now, I think Brion's going to say something towards the end about sort of the validity of the 14th Amendment as passed, but it's important to realize that even some leftist critics of originalism have said, okay, originalists, if you want to be faithful to your hermeneutics, to your interpretive mode, then you have to acknowledge that the 14th Amendment is invalid ab initio. You have to acknowledge that it was unconstitutionally passed by the very terms of Article 5 of the Constitution. Here's a sample quote from a law professor named Thomas Colby. He says, the 14th Amendment was a purely partisan measure drafted and enacted entirely by Republicans in a rump Reconstruction Congress in which the Southern states were denied representation. It would have never made it through Congress had all the elected senators and representatives been permitted to vote. And it was ratified not by the collective assent of the American people, but rather at gunpoint. The Southern states had been placed under military rule and were forced to ratify the amendment, which they despised with an unholy hatred, as a condition of ending military occupation and rejoining the Union. The amendment may have enjoyed military legitimacy, might makes right, and the factor on the battlefield can dictate the terms of peace. And it surely enjoyed moral legitimacy. Right is right, and the evil of racism flies in the face of freedom and justice. But it can claim no warrant to democratic legitimacy through original popular sovereignty. It was added to the Constitution despite its open failure to obtain the support of the necessary supermajority of the American people. Now, arguably, no other text besides the 14th Amendment has done more to expand the power and scope of the federal government. Presidential administrations come and go, whether it's FDR, Woodrow Wilson, Lyndon B. Johnson, they're just there for a limited time, but the 14th Amendment persists beyond generations. The 14th Amendment is a 5-section amendment, but Section 1 in particular has been the most litigated feature of the U.S. Constitution. Section 3 deals with the situation you mentioned earlier, Brian, with President Trump and whether he's disqualified from office for insurrection. But what we're talking about with Raoul Berger is principally Section 1, which contains 4 key clauses: the Citizenship Clause, Privileges or Immunities Clause, Due Process Clause, and the Equal Protection Clause. Privileges or immunities is one that Berger focuses on. And this states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Its original meaning was to ensure equal protection under the law, but it has been used instead to protect all sorts of other things. Now, actually, I'm actually jumping ahead to substantive due process, but privilege or immunities has actually been more or less dead letter since the slaughterhouse cases. But I do want to mention what Berger says about privileges and immunities. He says the phrase appears in Article 4 of the Articles of Confederation, Article 4 of the Constitution, and then entered the 14th Amendment by way of the Civil Rights Act of 1866, which refers to civil rights or immunities. And Bingham, actually, in the debates of the 39th Congress, says that the civil rights is a term that is an expansive term. And Berger makes the case that precisely because that term was expansive, is the reason why it was rejected. So that the framers of this document were deliberately trying not to design an expansive notion. That's why they got rid of the phrase civil rights. Berger also says that the purpose of the framers was to protect Blacks from discrimination with respect to specified fundamental rights enumerated in the Civil Rights Act and epitomized in Section 1 of the Privileges or Immunities Clause. So, in other words, he just believed that the purpose was simply to confer on freedmen the necessary rights to protect life, liberty, and property. I mentioned slaughterhouse before I misspoke, or after I misspoke. I mentioned slaughterhouse. Well, it held that the Privilege and Immunities Clause protects only rights regarding federal citizenship and not state citizenship, so that any alleged civil rights violations would be dealt with at the state rather than the federal level. You'll see arguments saying that the slaughterhouse cases ought to be overruled. My position on that is if you're going to go back that far to try to overturn that established precedent, then you really do open the door to throwing out the entire 14th Amendment as illegitimately ratified. Because if you're going to go back that far, there's a lot more evidence that the 14th Amendment was illegitimately ratified than that the court got the slaughterhouse cases wrong. The due process clause is where I was jumping ahead. This is where we get this notion of substantive due process. The due process clause of the 14th Amendment guarantees that individuals can't be deprived of life, liberty, or property by state governments without due process of law. It has been interpreted to include both procedural and substantive due process. The difference being the first, procedural, deals with legal proceedings, whereas the second deals with fundamental rights and unenumerated rights that are not named or specified in the Constitution. Much has changed since Barron v. Baltimore in 1833 held that the Bill of Rights, the first amendments to the Constitution, restrain only the federal government and not the states. Substantive due process has incorporated the Bill of Rights to apply against the states, and it has incorporated the first, second, fourth, most of the fifth. the Sixth, and parts of the Eighth Amendment to apply against the states. And look, some of these provisions in the Bill of Rights are great. I love the Bill of Rights. I love the Second Amendment, but I don't think that procedurally or as a matter of federalism or as a matter of interpretation, these should be applied against the state via the vehicle of the 14th Amendment. Berger complains a lot about federal criminal law. What does it mean when he's talking about nationalizing criminal law? Well, criminal law and family law were historically the province of state governments. And cases like Matt v. Ohio in 1961 regarding illegal searches and seizures, and Gideon v. Wainwright about right to an attorney, or Furman v. Georgia, in which the death penalty was declared unconstitutional as applied then. These are the types of cases that Berger is referring to when he's talking about when he's complaining about the federalization of criminal law. He also uses the term libertarian to refer to some of the holdings of the Warren Court, and what he means by that is several things, and I'll return to this momentarily. But he's talking about cases like Lochner v. New York, which held that there was a freedom of contract and that the state wasn't going to interfere with freedom of contract. Griswold v. Connecticut with right to privacy. Right to privacy is never mentioned anywhere in the Constitution. Roe v. Wade, of course, is based on right to privacy. Those types of decisions. Again, I'll return to his criticism of libertarianism in a moment. And just say a few words about the Equal Protection Clause. This mandates that all citizens be treated equally under the law by state governments, and it was adopted specifically to counteract the black codes that were passed after the Civil War by Southern states that discriminated against blacks. Now, to the point of incorporation and whether incorporation was intended by the 14th Amendment, Berger says that states have their own Bill of Rights precisely because they didn't expect the federal Bill of Rights to apply against them. There are all kinds of protections available under state constitutions, and they seem superfluous if you need to add on to them by incorporating things through the 14th Amendment. The federal Bill of Rights was motivated by a fear of federal power, not an embrace of federal power, which is in effect what the 14th Amendment does when it incorporates rights to apply against the states. It empowers federal judges to supplement the law as written with their own version of, say, fundamental rights. The scope of due process at the time of the drafting and ratification, according to Berger, was entirely procedural, not substantive. In other words, it did not deal with allegedly fundamental rights. Beyond procedural due process guarantees, the framers had no intent to incorporate the Bill of Rights against the states. Berger says they're only incorporating the provisions of the Civil Rights Act. The purpose of the 14th Amendment is to constitutionalize the Civil Rights Act of 1866. As for equal protection, Berger points out that after the 13th Amendment, freemen were still treated unequally. So the Equal Protection Clause is set out to constitutionalize the Civil Rights Act of 1966, which means that it's trying to enable these freedmen to enter into contracts, hold property, sue, do those sorts of things. We're not talking about rights to privacy or freedom of contract. These are very different matters. The framers sought to give to blacks the same specified rights that whites enjoyed at that time. So in other words, if white Americans did not enjoy a right at the time of ratification, then nobody would have enjoyed that right 100 years later or 200 years later. Berger is trying to protect against the invention of new rights. So if there was, at the time of ratification, one law for whites and one law for blacks on the same matter under same circumstances, that's what he's worried about. He wants equal. That's what the ratifiers were worried about, according to Berger. They're not worried about some potentiality in which new rights might be born at later times. I mentioned that I would come back to libertarianism, and that's what I'll do. Berger criticizes what he calls libertarian and laissez-faire readings of the amendment. It's popular among many libertarians today to champion the 14th Amendment. It's common among people at the Cato Institute or the Institute for Justice. And I think this is a results-oriented thing. For example, libertarians see freedom of contract as a result of Walker, and I think that's great. They see right to privacy, and they think that's great. They think that they see right to buy contraceptives, and they think that's these are great things. Free speech, freedom of the press from like Gitlow and Abrams and cases like this, they see those as great. But here's where I think that libertarians taking that position are missing the point. First of all, the federal government is neither the only nor the best means for countering some of the generic bads that have recurred throughout American history. So, for example, discriminatory practices and policies. Is the 14th Amendment really the best way of eliminating those? I don't think that it is. I think it would cause more problems than it solves. Also, I believe libertarians favor non-governmental and decentralized approaches to neutralizing discriminatory practices and institutions. The Equal Protection Clause and the Due Process Clause have specifically been used to get at private activity and not just state activity. And we have law professors on the left, people like Erwin Chemerinsky, Charles Black, Peter Edelman, and Frank Michelman, who have propagated this notion that rights to subsistence are fundamental rights, which would require states to supply government-provided food, healthcare, a minimum wage. Obviously, these are not rights in the sense that the ratifiers of the 14th Amendment would have adopted them. And this is the danger of going down this road toward abstract fundamental rights and letting judges who are not philosophers, by the way, federal judges are not philosophers, letting them determine what a right would or would not be. In fact, I would find the American law schools and federal judiciary to be probably the most unfriendly fora for libertarian views. We don't need the federal judiciary to secure these types of rights because Congress can pass amendments to the U.S. Constitution to do it. Members of Congress can be voted out of office, whereas federal judges hold life tenure. And so I believe that Congress is the appropriate vehicle for such action. The other thing is if you take this idea that, well, look at the results that we're getting out of the 14th Amendment that you hear happen among libertarians a lot. Look at the results. You've got all these good things happening. Well, if you are going to celebrate just big picture federal intervention into local affairs on such consequentialist grounds, that's a close step toward asserting that libertarianism is fundamentally wrong, because a centralized paternalistic power is much better at advancing liberty than decentralized government. You're essentially one step away from delegitimizing your own cherished theories. I mean, under that logic, you would say, oh, the Iraq War was great because America intervened in a foreign place and ensured liberty. That's not a very sound libertarian position to take. And opposition to the 14th Amendment shouldn't be taken as endorsement of the views that have been combated by use of the 14th Amendment. And it's not about state rights or state sovereignty necessarily. It can be, but it's not necessarily about that. It's about limited government and decentralized power. Since 1950, the number of federal governments has more than doubled. But guess what? Nothing in the Constitution specifically authorizes federal review of legislative acts, judicial review. The only federal court required by the Constitution is the Supreme Court. Congress can create other courts or eliminate courts if it wants to. The federal judiciary, allegedly the least dangerous branch, has grown to overwhelming proportions and, in my view, has caused more harm than good over the course of our history.
All right. Thank you, Alan. And we appreciate that. So if you have questions for Alan, hang on to them, because at the end of the third presentation, we'll be able to ask those. And I know some people have started asking questions, so hang on to those. But we're going to move it now to Bill. So Bill, you're up. Thank you.
Well, thank you, Brian. Alan, great presentation. Enjoyed hearing you right there myself, just like I was a member of the audience. Ladies and gentlemen, I think really when you look at Berger's book, what's the key question that he asked? And Alan hit on that in his presentation, but I think you could even whittle it down simpler. Who is to decide, right? How is our government structured for decision-making authority? What level of government? What accountable representatives and such? And the whole premise that the framers of the 14th Amendment intended or thought that they were empowering a Supreme Court, unelected judges with no accountability, of course, with impeachment having been a scarecrow, as Mr. Jefferson would describe it early on, that these framers of the 14th Amendment would think it proper to vest such power in the judiciary, which, Berger, of course, described some of their actions as a roving constitutional convention. That is a ludicrous conclusion there, especially when we look at the circumstances around the amendment's drafting. One of the key purposes of the amendment from the very get-go was to overturn a judicial decision, Dred Scott, in which the Supreme Court essentially held that while blacks were persons under the Constitution, they could never be citizens. They could never could be part of the pre-existing political communities that formed the Constitution of 1787. Moreover, the court goes on to invalidate the Missouri Compromise, again, a political compromise by elected representatives regarding the issue of slavery in the territories, using, some would argue, a precursor of substantive due process, as Alan has talked about. There are disputes we can raise with that, but nonetheless, it's often pointed to a precursor of a heavy use of federal substantive due process. So the idea that the radicals or other members of Congress would want the court somehow to be invested with this broad authority under the 14th Amendment just does not match up to history. At this time, the court was at a low point in the eyes of many of the members of Congress for, again, their effort. Justice Taney, no doubt, hoped, and his plan was that with Dred Scott, he could solve the slavery in the territories issue, stop all the madness. Everyone would accept a pronouncement from the Supreme Court and avert a catastrophe. Obviously, that didn't quite work out as he planned, but he, in good faith, I think, tried that. And it obviously, things had moved too far along with distrust in the sections. So that's my first point. The idea that the Republicans wanted to empower the Supreme Court via the language of the 14th Amendment has no basis in history. Further, if you simply look at the text of the amendment, Section 5 to them was where the power lay to enforce the 14th Amendment, and that was Congress. Congress has a power to enforce the 14th Amendment via appropriate legislation. And courts don't like that. We even saw that with some of the concurring justices in the Trump case that I believe Brion and Alan mentioned just briefly. All 9 had no problem agreeing that a state could not exclude a candidate from a federal election under this idea of insurrection. And everybody is in agreement on that, all 9. Where they break down is that many of the, say, more liberal justices, and Justice Barrett doesn't really show her cards there. She just says, I wish we hadn't have gone any further. but the more liberal justices like, whoa, what do you mean this in the opinion? Congress is the one that enforces the 14th Amendment, and Congress is the one that's enacted an insurrection statute where one can be convicted, and therefore that's the mechanism where this is enforced. No, they want to retain hopes of judicial power to, in the appropriate case, exclude someone from the ballot. So we still have these arguments today, but for the framers, it was Section 5. Congress is going to enforce the 14th Amendment as needed. And Berger points out that rather than the big ticket items that we are going to talk about today, obviously the due process clause, privileges and immunities, etc. there, the big deal for them was essentially the idea that you could, one, exclude former Confederates from office because the radicals were afraid that, as Alan mentioned, that Confederate soldiers and sympathizers, with the removal of the 3/5 clause with the 13th Amendment, would swarm Washington and overpower Republican rule. So that was a more important provision to them than anything with privileges and immunities and due process there, as well as the power Congress has to reduce a state's voting power if they discriminated in their elections and such. Where obviously that doesn't really apply to the North, where a state like Massachusetts might have, a 1% or less Black population, but that would be a stick you could use against an Alabama, where you're reaching 50 to 60% of a Black population there. So those were the important provisions to the framers. I think Berger does a nice job of pointing that out and pointing out just how ridiculous outside those provisions, say modern one man, one vote legislation is, or various apportionment decisions from the Supreme Court, because Bingham, Howard, and others were very clear. They were talking not about political rights in the 14th Amendment, which they understood rightly not to include voting and other such matters, but the things Alan's talked about, life, liberty, property, the big three, as outlined in the privileges and immunities clause and such, as outlined in Blackstone there as well. And it's really, as he pointed out, it's how can we constitutionalize the Civil Rights Act of 1866 so Blacks can have access to the courts, testify in court, own property, have these fundamental rights that are necessary to human existence there. And that was the purpose of it. Many wanted to argue, well, the 13th Amendment provided that authority. But if you look at the 13th Amendment strictly and properly, it outlawed the institution of slavery, of bondage there. To stretch it further was questionable, which is why we have a 14th Amendment to begin with, is how can we protect the Civil Rights Act of 1866? How can we constitutionalize it? As Berger says, enter the 14th Amendment to do that limited thing there. I often tell my students when we turn to the doctrine of incorporation, now did the framers intend to incorporate the Bill of Rights? I say, if we could almost take a John Rawls original position, and you have not heard any lectures from me on the 14th Amendment, or even done any of your independent reading, and I just tell you, go find me in the Constitution, amendments and all, where the Bill of Rights applies to the states. My wager is not a one of them is going to come back even pointing to the 14th Amendment, much less the due process clause. Probably not the Privileges and Immunities Clause either, insofar as from Section 4 in the original Constitution, it had a very narrow interpretation. Essentially, states had to treat out-of-staters equally with regard to such benefits by grace that the law allowed. And that was still very limited. Even the Corfield case that so many 14th Amendment scholars will cite, Justice Bushrod Washington's opinion, or dicta really in that opinion, where he essentially upheld the right of a state to exclude out-of-staters from digging oysters in that state's shores, but then goes off on some just flowery language about, well, what are privileges and immunities, and actually includes voting in there, though no one would ever at the time have done that. But you have this high sounding language in dicta that many have grasped, though state court decisions interpreting Section 4 never went that far. I think Justice Washington, that was just a fairly confused opinion. It's not a solid foundation to build a doctrine of incorporation on. But I digress there with Washington. And you could not find in the text, in the Rawlsian original position, where in the world any sane man would conclude the 14th Amendment has been incorporated. I'm sure one of my students could draft a much better provision or statute if that was ever the intent to do so, rather than leave it to chance. But I think the answer to that is, why is it so hard to find such a provision, is because they didn't intend to incorporate the Bill of Rights. And yes, we can point to some stray comments from Bingham and Howard that say, well, this is going to incorporate the first 8 amendments against the states. And yes, the New York Times ran with a headline in an article from some of that language at one time. And Justice Thomas, for example, focuses on Bingham and Howard's statements in his arguments that the 14th Amendment did intend to incorporate the Bill of Rights against the states via the Privileges and Immunities Clause. Thomas, is correct that due process, as Alan said, everybody understood that to be procedural. That before a court you can be deprived of life, liberty, or property, you must have process, i.e., if in a criminal case, indictment by a grand jury, the right to counsel, the right to call witnesses in your defense, process there, a right for this to be heard by a jury of the vicinage or the district, as the federal Constitution calls it. Everybody understood that. So Thomas focuses on the privileges and immunities aspect. So what do we do with Howard and Bingham and these statements? They're in the record of the 39th Congress. How do we look at that? Well, I think we see these, Berger nicely describes Bingham as a stump orator, given to windy rhetoric there. And actually, if you look at some of Bingham's other speeches in the House and such in the Congress, he contended at times that the Bill of Rights already applied to the states through the Privileges and Immunities Clause in Section 4 of the original Constitution, which is just crazy. It didn't. Even Alan talked about Barron versus Baltimore. Even Justice Marshall, the great nationalist, when presented squarely with an opportunity to hold that the Bill of Rights applied to the states, he could not even bring himself to go that far. And essentially, in Barron, he says, look, everybody around at the framing knows that the states were afraid of increased national power. They demanded certain securities, a la the Bill of Rights. Nobody ever intended this to apply to the states. So, Bingham comments such as that, they're just completely unsupported in the historical record. How far you can trust his personal beliefs on what the 14th Amendment was doing. I don't know. I think you have trouble there, especially when, let's look at this, you don't see a number of Democrats or even moderate Republicans standing up and saying, whoa, this amendment is going to work a revolution in state criminal law and state constitutional law. For example, states are going to have to, if we incorporate the first 8 amendments, supplement the use of grand juries and other matters that are now required via incorporation. It would really have worked a revolution in state law. So we're going to have trials, civil trials, where the amount in controversy is over $20, according at least to the text, clear text of the amendment, a 7th Amendment in that case, etc. Nobody made those obvious arguments. And Berger argues, and I agree, why didn't they? Because nobody believed that the 14th Amendment was incorporating the Bill of Rights against the states. Moreover, when you look in the aftermath of passing the 14th Amendment, there is no constitutional revolution in the states altering their provisions of constitutional or even statutory law to comply with the federal Bill of Rights, especially in this realm of criminal procedure, where they would really have been affected more. You don't have that. Probably, I think, the strongest piece of evidence I find, Berger, he doesn't really discuss the case in full, though he cites it. One of his footnotes is the Twitchell case. I believe it's Twitchell. I don't have my notes here. But essentially, 4 months after the 14th Amendment is ratified, the Supreme Court of the United States is given the opportunity to deal with a state criminal law matter where a criminal defendant is raising that an indictment was poorly drafted and did not put him properly on notice of what he was charged with. It was a manslaughter charge, etc. So he raises the 5th Amendment to the Constitution, some 6th Amendment claims as well. So if the 14th Amendment has incorporated these against the states, and the Supreme Court has been there, the justices in the thick of this momentous occasion, listening, reading the papers, certainly at their lodging places, talking about what's going on in Congress, probably breaking bread with senators and congressmen as well for dinner and such. They don't mention the 14th Amendment. They indicate doesn't the Bill of Rights, these particular 5th Amendment in this case, doesn't apply to the states, but they're, again, legal minds, have front row seats to this spectacle in Washington, D.C. And it's so if anyone had have truly understood the 14th Amendment to apply to the states, certainly those justices would have. But we don't really see any incorporation, i.e. applying the Bill of Rights to the states, until we start to hit the 1920s. And that's very rudimentary there. And then, of course, we march forward and the court tries to come up with excuses for it. And then, of course, Hugo Black and Adamson is the first justice to really take a stab at looking at the historical record and arguing for, Black was a total incorporationist. To his credit, he didn't like the court picking and choosing which rights to incorporate, but he did a bit of bad history in his first run through to support incorporation, but he thought it was better than selective, where the court, depending on its mood, the times, it picks particular provisions of the Bill of Rights to incorporate against the states, which is essentially the system that we have today. Of course, the biggest move on that recently in our lifetimes would have been the McDonald versus Chicago and the Second Amendment incorporation. against the states, though we have since obviously had others. I believe the fines clause a couple terms ago, the Supreme Court incorporated against the states, where I believe it was Indiana, or I forget which state exactly. Anyway, they take some guy's Land Rover and seize it when his maximum criminal exposure was only a couple $1,000s, and found that not proportionate and applied the fines clause. So it's still a relevant issue to us even to this day. So while I would applaud Justice Black at least on wanting to stop the picking and choosing, his big failure obviously is buying into incorporation. And Justice Thomas, who I think probably most of us at the Abbeville Institute, when we read his dissents and such, like, yeah, this is our guy. He is on board with our vision of the Union, that the people themselves should decide rather than unelected judges. But even Thomas has bought into incorporation. And my class at Wofford, I always have my kids read his concurring opinion in the McDonald case on the Second Amendment, where essentially he uses the Glucksberg test from Washington versus Glucksberg that the conservatives have on the court have crafted, where to be applied to the states or even through substantive due process, it has to be a right that is intrinsic in our system of ordered liberty, and have deep roots in the nation's history. Of course, we see that language is obviously in the Dobbs decision, is what Alito cites when he says abortion is not. Doesn't fit either of those prongs itself there. But Thomas, a great legal mind who I have a lot of respect, he comes out on the other end of this, and I think some of that is no doubt maybe his mentors were Straussians, and this whole natural law theory from some of the Straussians is incorporated via the 14th Amendment, might have permeated some of his thinking there. But again, he's a great judge, great justice, but I do think he gets it wrong there. And one last thing before I pass to Jesse to tell us what's really going on here is, let's not give short shrift of what Alan mentioned with substantive due process, which I just brought up, because incorporation and substantive due process are twins in a way. This whole idea that the court can take certain unwritten fundamental rights. Now, with incorporation, we're talking about specific provisions of the Bill of Rights and applying them to the states. But with substantive due process, the idea of this procedural doctrine somehow has a substantive component where the court can judge reasonableness of state legislation and therefore apply certain rights out there from the ether that they think states should have to respect, whether it be abortion, privacy, what have you there. Again, this is part and parcel of the same thing that courts, not the people's representatives, should make these calls and make these decisions. That individuals who are not elected, who are not accountable, are the ones who incorporate, are the ones who apply unwritten rights against the people's elected legislative bodies. And again, it comes back to, as I started with, what Berger was getting at. Who is to decide? Is it black robe Platonic guardians who we cannot rebuke at the ballot box? Or is it our representatives who, at least in theory, we have a vote and we can boot out of office? I think I would choose the latter system, as Berger advocates for. So that would be my opening statement on the 14th Amendment, and I can't wait to hear from Jesse.
Thank you, Bill. I appreciate that. And great presentation again. Both Alan and Bill have done a great job. And we're going to have Jesse back clean up now. So we're going to turn it over to Jesse. Thank you for coming out for us.
Well, as a baseball fan, I appreciate the analogy. And thank you, Brian, Alan, and Bill. Bill, that was just an excellent summary. And I'm going to have a hard time really getting into the details of the Berger book because you went through it so well. One thing I would add is that in the discussion of John Bingham's inconsistency, there is a really good book on that subject. I mean, it's praising John Bingham, but noting the inconsistency in which he would talk about things like incorporation and what the Privileges or Immunities Clause meant. At times, he would treat the Privileges or Immunities Clause as though it meant exactly what the Privilege and Immunities Clause in Article 4 means. That book is American Founding Son, John Bingham and the Invention of the 14th Amendment by a law professor at Indiana University, I believe, Gerard Maglioka. But there's an entire chapter on that inconsistency that Berger certainly mentions, as you noted, but this book just goes through all of it. And it is interesting that when it comes to this history, those scholars on the left, like this law professor, are actually probably more honest about the inconsistencies, not only in the adoption of the 14th Amendment, something that Brian's going to talk about, but also in terms of what they thought it meant. And part of the reason why they're more honest is that they're not tethered to this notion of originalism. Because conservatives are so tethered to originalism, and because they have a hard time, or many of them have a hard time pushing back against where the regime is right now on a whole host of issues, they have to, unfortunately, manipulate a lot of the data, the historical data, in order to yield the results that they want, so as to be more palatable to our modern sensibilities. And just to have a sense of the political context of the book, it's obviously a historical work, and Berger was principally a legal historian, but it is obviously written in 1977 for a particular political cause. And that has to do with the Warren Court. And I don't think that's something that we've covered so far. So it's worth mentioning to our audience exactly how transformative the 14th Amendment was in terms of American social relations. So just about everything that divided Americans in the 60s and everything that continues to divide us now has been given to us through the Supreme Court's authority over our social life via the 14th Amendment. So you could just go down the list: sexual morality, abortion, homosexuality, race relations, immigration, criminal procedure, even federalism itself, through incorporation. And that's something I don't think we talk about enough. You know, we legal scholars often think about incorporation in terms of whether or not, you know, certain rights are fundamental, or in terms of what privileges or immunities means. It's important to think about what it actually does to the 1787 system. It expands federal power by making all of these disputes that I just mentioned, which are very local in nature, right? How we're going to treat abortions, how we're going to treat criminal law, how we're going to deal with homosexuality, how we're going to deal with school prayer and the operations of running a school, administering a school. These are police power issues. But through incorporation of all of the Bill of Rights, including the Establishment Clause, which is the most ludicrous, of course, of all, given what the Establishment Clause means, all of these issues now all of a sudden become not just federal issues, but federal judicial issues, managed ultimately by the U.S. Supreme Court. If you just think about how that juridicizes our political affairs, what I mean by that is it turns our political disputes into matters of law to be controlled by courts. It just reconfigures the entire separation of powers, the horizontal distribution of powers, and the vertical distribution that we have in federalism, so that the court gets to regulate things that Congress could not regulate via Article 1. Right? So the court's essentially regulating abortion life. Life issues through controlling abortion, or criminal procedure, or race relations, and so on. Things that Congress could not do via the Commerce Clause, but the Supreme Court could do through incorporation. And at the same time that it expands federal power, it diminishes state police power. And it, maybe even more importantly, really renders state courts as mere subsidiaries of federal courts. So at the founding, the state courts, of course, had their own independent constitutional traditions and had distinctions in terms of how they dealt with their state constitutions. Now, being a state judge doesn't mean that much. It's really just secondary to being a federal judge. And as a result of that, state judges, when they interpret their own constitutions, merely mirror what the federal courts have said about the US Constitution. So they don't embrace this idea that, wow, I'm a state judge with my own state constitution, my own provisions, to think about what this means for my state. Rather, I'm just going to look at what the US Supreme Court has said about due process, and I'm going to apply rational basis here or strict scrutiny or whatever. So that everything at the federal level gets mapped onto the state level, so that all of the distinctions of American life get swept away and homogenized. That's the profound effect of incorporation. It's not merely that, okay, we have the first 8 amendments applying to the states. It's that all the varieties of American life get swept away and homogenized, and also get juridicized, meaning controlled by the courts at the same time. And that, of course, makes us much more polarized, because we don't have the access through living in different states or through elections to change matters. Because 330 million Americans are subject to the whim of 5 people in Washington, D.C. You just need 5 votes, right? And you could change the lives of 330 million Americans. And that, if that isn't tyranny, I don't know what is. So that's the political context in which Berger is operating. All of these changes came not immediately after the 14th Amendment is ratified, but actually about 75, 80 years later. So obviously there's the Lochner period, which is relatively short-lived and goes away, by the New Deal. It's not so short-lived, but there's a lot of pushback. And by the time of that Berger's writing, that's no longer much of an issue. All those cases get overruled essentially by the New Deal court. But now you have the Warren court. And the Warren court is much more aggressive than anything that was done during the Lochner period. Now, all of a sudden, we're transforming pretty much every dimension of American life, and it's almost exclusively through the 14th Amendment. And that's the political context in which Berger is operating. It's important also to know that the term originalism didn't even exist at the time that Berger is writing. Nixon, of course, in '68 uses the term strict constructionism, and many people treat that as the beginning of some sort of originalist movement, a proto-originalism. Robert Bork in 1971 writes a seminal law review article, which he talks about neutral principles, which is a development of an article that Herbert Wechsler wrote in 1959 in the Harvard Law Review on what it means to have the rule of law. To have the rule of law, according to Wechsler, required that courts act according to neutral principles. Bork takes that further and says, well, also the derivation of the neutral principles, not just the application, that itself has to be neutral. And that points to the idea that they can't just come up with political principles. They have to be derived according to the original meaning of the document. Berger goes farther in 1977 in this book and says, well, if we're going to have neutral principles, we have to look to the historical materials. And he's obviously taking aim at the 14th Amendment in particular because of how the Warren Court had been using it. The Warren Court had ended in 1968, but the Berger Court essentially continued what the Warren Court had done. Some people forget that Roe v. Wade is actually a Berger Court decision, not a Warren Court decision. Likewise, Lemon v. Kurtzman is a Berger Court decision, right? Berger did a lot of the stuff that Warren had been doing. So Raoul Berger, not Justice Berger, Chief Justice Berger, but Raoul Berger is essentially countering this, at this point, about a 25-year trend in the Supreme Court. And he's pointing out in the very title that the federal judiciary is actually governing us via the 14th Amendment. So this is a substitution for the model of governance developed in the 1787 Constitution. So originalism comes about really as a result of this book. I think it's just 3 years later, in 1980, Paul Brest, a law professor, writes an article in which he says what Berger and Bork, he identifies both of them, I believe, in the article, what they're doing is weird, right? This is just strange, because you have to remember at the time, constitutional law scholarship is all about coming up with ways to justify what the Warren Court had been doing according to what was called then the counter-majoritarian difficulty. So how do we reconcile, they would say, this idea that we love these decisions, but we realize that they're not in the text of the Constitution, and we are, Democrats. We're in favor of democracy. So how can we come to terms with the fact that we like these results, but they're being enforced through courts that are not elected in their life tenure? And you get Ronald Dworkin writing on that, and Alexander Bickel, and so on. When Brest is saying that these are weird people, he's saying that obviously derogatorily, right? And he's saying something's going on with conservatives. When the Federalist Society is formed, which is actually like the following year, I think they start planning, these three law professors at Yale and Chicago. They start talking about it in 1981. I think it's a year after the Brest article, and they formally established it in 1982. So it's in this time period. But interestingly, FedSoc does not actually announce we are originalists. That's how obscure it was at the time. It's certainly emerging, but it's not, something you would say, I am an originalist. In fact, when Justice Scalia, this is something that a lot of scholars, I think, overlook. When Scalia was a law professor at UVA at Chicago, when he's a DC Circuit judge, never once called himself an originalist, and none of his scholarship, none of his work on the DC Circuit sounds like an originalist. He's not interested in legal history. It's really Bork who's more of an originalist. But of course, Scalia and Bork are competing essentially for a Supreme Court nomination in 1986. By that time in 1986, originalism is starting to become more prominent, mostly because of Berger. Because I think it's Alan who mentioned Berger writes this in 1977, but he spends like the next 20 years defending it. I think his Incorporation Law Review article is, forgot how long it is, but it may be close to 100 pages long. It's much longer than the chapter. I think it's like chapter 8 in this book. That's only like 30 pages on incorporation. His law review article is like 3 times as long. So this is his life's work, essentially. It's defending this this account of the 14th Amendment. So by the time of 1986, originalism is a big deal, so that when Scalia is up for a potential nomination, he announces in a speech at the Department of Justice, he's an originalist. But he says, I'm not an original intent originalist like that guy, Robert Bork. I'm an original public meaning originalist. That's how you get the public meaning turn. It's a more palatable way of doing originalism. That's the last thing I want to talk about with originalism. It's a complicated subject. But this turn is important because with original intent, obviously intent is a fiction when you're talking about a collective body. Excuse me. But it is meaningful in a sense because you could look at 1868, you would have a hard time saying, well, they intended X, Y, or Z. But you also would have an easy time saying they didn't intend this. No one in their right minds could say that they intended to do anything with abortion or same-sex marriage, right? That wasn't an issue at the time. So if you're focusing on intent, you could say, well, I can't learn everything about what this collective body wanted, but I can figure out what they were not thinking about because it wasn't talked about, right? They're not thinking, obviously, about abortion or same-sex marriage or anything like that. Original public meaning is an important shift because it makes it more linguistic. So now all of a sudden, I'm not confined by what they talked about in 1868. I'm broadened to think about equal protection as such, or privileges or immunities as such. Now, I am confined by the understanding of that language, but language can have an evolving application based on our understandings, right? Changing over time. So the way that a lot of the so-called new originalists operate is they say, well, it's about equal protection, and equal protection may have meant one thing in 1868, but it was really about this principle. Perhaps that principle is about not having a distinction between one class of citizens and another. And just as that applied to white and black people in 1868, well, it could apply to men and women, right, in 1973, or pregnant people and non-pregnant people or something like that, or to straight people and homosexual people. So the same principle, the same text could be used to change how the 14th Amendment is applied. Original intent prevents that from happening. So even though it may seem like a mere matter of like nomenclature, just lawyers kind of nerding out over this, it actually has significant application differences. And no one at this point, at least not on the Supreme Court and the Legal Academy, calls themselves an original intent originalist. And I think part of the problem is philosophical, right? It's the collective intent problem, but I think it's also partly political. What would that mean for all of these issues that I just mentioned that have been created through a much broader understanding of the 14th Amendment? I've got a few more minutes, so let's talk a little bit about Bork's understanding of the 14th Amendment. I mean, obviously, both Alan and Bill covered this extremely well and extensively, but there is one thing we haven't talked about, I think, which is the 1866 Civil Rights Act. Berger's entire idea is that the 14th Amendment is confined by the history, which means you have to look at the context in which the 14th Amendment is proposed. And that context is the 1866 Civil Rights Act. This, of course, was thought to be unconstitutional because Congress had never done anything like regulating property rights, contract rights, and criminal law procedure, which is what the act did. And that's why it was, of course, vetoed by President Johnson. Now, in that book that I mentioned, American Founding Son, Professor Maglioka mentions that Bingham bought into that. Now, whether he did that for strategic reasons, I'm not so sure. And I don't recall if Maglioka actually takes a position on that. I don't think it's clear. But Bingham pretty much says, yeah, we can't do this. Congress can't do this, which means we need a constitutional amendment. Berger takes that to mean that the 14th Amendment is about those three things that the Civil Rights Act of 1866 is about, which are those three things are property rights, contract rights, and criminal or juridical rights, meaning rights dealing with courts, right? How laws are administered. And that would mean, of course, that I couldn't have a right to acquire property that a black man could not, or I couldn't have the right to enter a contract that a black man could not. I could not have one penalty if I commit a crime and a black man have a different penalty, right? That's the idea of the 1866 Civil Rights Act. And Berger essentially says that lawyers misunderstand the 14th Amendment when we treat those rights as though they are independent of one another. To the way that we teach law, the way that the Supreme Court teaches does the 14th Amendment, is we think of them as three independently operating provisions, right? We do due process law, and that creates all these substantive liberties that we've all talked about. Equal protection law, which deals with all the classifications coming out of the civil rights movement and so on. And then we have the Privileges or Immunities Clause that some people want to revive. Berger says that's a mistake to treat them as though there's A, B, and C. They're all going after the three rights that the Civil Rights Act of 1866 is about, right? It's all about contract rights, property rights, and these criminal rights. But it has to do with different features of them, right? The Privileges or Immunities Clause is about having those rights, property, contract, and so on. Equal protection has to do with having to apply them equally. And due process has to do with how they're administered. But it's not as though there are these three rights that are going out independently, and you just think about them as three different spheres, which is the way, if you teach Con Law 2 in law school, I'm teaching it right now, you teach part of the semester, equal protection. I just completed that yesterday. And then the rest of the semester, due process, right? Berger would say that is not how the 14th Amendment is supposed to operate. They're working together to secure these rights. And that's what the 1866 Civil Rights Act was about. That's what the 14th Amendment is trying to accomplish. Last thing I'll say is you could see why no one could accept this today. Because if you were to limit the 14th Amendment to really what the 1866 Civil Rights Act was about in terms of three different ways of getting at these rights, pretty much all of the Supreme Court's jurisprudence, not just 14th Amendment, but the Supreme Court's essentially just a 14th Amendment court, right? Most of its individual liberty stuff, at least, is 14th Amendment jurisprudence. And of course, it's hard to get incorporation out of that. It is important for all of us to note that Bingham did talk about incorporation, but incredibly, just erratically. And my whole argument, and I'll end with this, is it's not that incorporation was on no one's minds. I mean, there was a pretty significant, I don't know about the number of people, but there was a sense that this dealt with the Bill of Rights. But there wasn't enough of a sense, in my opinion, to transform the entire document. And that's what incorporation does. And I think that the proper understanding of constitutional law is that there's a gravitational pull of what came before. And you can't just say the 14th Amendment could be interpreted as incorporating and therefore should be interpreted that way, given what incorporation does essentially to the separation of powers and to the vertical distribution of powers that we call federalism, right? I think that's probably the strongest argument against incorporation. It's not that no one thought about it at the time, but there's clearly not enough evidence that this is what they meant to do, given what that would do to our constitutional system and has done to our constitutional system. Thank you.
Thank you, Jesse. Jesse, excellent. So all these presentations were very, very good, and I thank all our presenters for giving us this information today and talking about Raoul Berger and the 14th Amendment. I'm going to talk briefly about a question that was actually asked. Was it legally ratified? And Alan actually brought this up, that there is some question about this, and if we're going to be consistent, then you have to talk about that particular issue. And if you put that to a ratification debate today, if you put the 14th Amendment out there, I'm sure that it would be ratified. I mean, you might have some states push back against it, knowing what we know about how it's used. But if you go back to 1868 and you look at the ratification process, it was pretty squirrely. I think you had, of course, the southern states, which had been booted out of the Union, which is absolutely hilarious that for 4 years, the North fights a war saying you can't leave. And then when they come back, well, you're going to leave. That's funny in and of itself, but you're now not a state. This is Stevens' conquered province theory, and you're out. But to come back in, you have to ratify an amendment. Now, if you look at the Constitution itself, a state cannot. It's not a state cannot ratify an amendment. A territory can't ratify an amendment. It has to be a state. So other states began looking at this and saying, well, if you're going to do that, well, that becomes highly problematic legally. So we actually had 3 states rescind their ratification agreements. And that's where it got interesting. And Forrest McDonald has a very good article about this at the Abbeville Institute. In fact, I think one of the participants or attendees actually posted that in the chat box if you want to go out and read that. But it's a really good article on this. And some people were talking about this in the 1950s and 60s and in the 70s because of all the issues we've been discussing. Everyone recognized the 14th Amendment was the way that was going to transform the United States through the court systems, not through the legislative body. What the left couldn't get through the legislative bodies, they were going to get through the courts. They understood it. This is why it's so funny today when they're all attacking the court. We need to get rid of the court. The court's got to pack the court, disband the court. That's the only way they got their agenda. I mean, it's absolutely hilarious when you think about it. They're all turning against the thing that brought them to power to begin with in so many ways. So, but 3 states did rescind their ratification agreements. Now, what's important to note about that is if you go back to the early 19th century and look at John Taylor of Caroline, who's somebody we talk about at the Abbeville Institute a lot. He actually wrote a book entitled New Views of the Constitution of the United States, where he had a section on sovereignty. And he says this in this chapter, that legislatures can actually rescind the acts of conventions. They can go in and say, all right, well, because we're sovereign, we can take this back if we choose to do so. And so 3 states actually did that. Now, when the 14th Amendment goes out for ratification, you can either do it in convention or through the legislature. So one legislature can rescind the act of another legislature before the amendment is actually promulgated. And this is what happened. So if that actually did happen, and it did, then you didn't have enough states to ratify the amendment, but it was ratified anyways. So that's really the argument. It was never really legally ratified, but the Republicans knew they had to do something and they didn't want to wait around, so they just did it. Here we go. We got the amendment. And that becomes really dangerous if you think about it, because it's extra legal at that point. But it has been used now as this hammer. As I said at the beginning, it really is the Constitution. As Jesse said, this is what we do at the Supreme Court now. Everything they do, you read all the opinions that come out of the court, and you've got a situation where the court is going back to the 14th Amendment in one way or another to justify what they're doing. Even the originalists, quote unquote, on the bench use it a lot to justify their positions. Now, amazingly enough, in the Dobbs decision, we talked about Thomas. He actually brought this up, and he said, well, wait a second here. If we're going to say this thing is, Roe v. Wade's going to be overturned because we're going back to federalism, what about all these other things that we could look at that are a problem with the 14th Amendment? And that's where people went really ballistic. Oh my gosh, what are you saying, Thomas? You can't say all that. That's going to undo everything we've done. That's when people really started getting upset with the court, because if that happens, well, then, as Jesse said, you just overturned decades of Supreme Court decisions. I mean, it would be cataclysmic in some ways for the federal bench. The other thing he brought up, which I thought was interesting, is this position of state judges now being subservient or subordinate to federal judges. This was a big issue in the 19th century. In fact, you go back to the Cohens v. Virginia decision, where the Virginia State Supreme Court was saying we're equal with the U.S. Supreme Court, and Marshall tried to smack them down there, and so did Joseph Story. That was always an issue. And there's just a couple of things historically, as we've gone through this conversation before I start asking questions, that I thought about. One was John Rutledge of South Carolina in the Philadelphia Convention, when a federal negative of state law was brought up. Rutledge says that alone ought to damn the Constitution. That's his words. That alone, that thing, a federal negative of state law should damn the Constitution. We should just all go home if that's going to happen. And that's exactly what the 14th Amendment has allowed to the Supreme Court and the federal courts to do. It's created a federal negative of state law. So if the founding generation had ever thought about this, or they did think about it, if they thought it was going to happen, you wouldn't even have seen the Constitution ratified. That's something we have to understand in all of this. The other thing about Madison in the Bill of Rights, and we, of course, Bill brought up Barron v. Baltimore and the Marshall decision, where he said, yeah, the Bill of Rights don't apply to the states, they just apply to the general government. Well, there was actually an attempt to give us kind of an incorporation amendment when the Bill of Rights were going through the ratification, or the discussion process in Congress, not the ratification process, when they were actually being discussed and debated in Congress. There was an attempt to have an incorporation amendment, and it was struck down. They didn't want that. And you have to understand that in 1788, and 1789, and 1790, there were states in New England that had state-established churches. If they really did believe the Bill of Rights applied to the states, well, then those state-established churches would have been unconstitutional, but nobody thought that. The Bill of Rights only applied to the laws that Congress would pass. This only dealt with the federal government, the federal Congress, and not the state Congresses, which were, if you think about the model that Americans had in mind, you go back to the Revolutionary period, they said our colonial legislatures are on equal footing with the Parliament. They looked at their own legislatures on equal footing with the Congress in the areas in which they had powers. So what we've done is we've made even the state legislatures subservient to the Congress through all of this, which is the real issue when you start talking about incorporation and nationalism, whatever you want to say it is. That's really what we're doing. We're nationalizing everything in the United States. And when you do that, when you have 535 members of Congress, the president, and then 9 Supreme Court justices, and you need a bare majority of any of that to get anything done, and you're governing 330 million people, you can understand why people are angry, why they're unhappy, whether on the left or the right, and looking at this and saying, "Gosh, I don't want these yahoos in Alabama governing me if I'm highly enlightened here in California." I mean, what do these people know? They're stupid. And then you can look at the people in Alabama saying, well, I want these intellectuals in Massachusetts or these Birkenstock-wearing people in Vermont telling me what to do. I'm going to do what I want here in Alabama. So this creates a real situation where we have all this angst because you've nationalized everything. And I think that's the thing that we need to take away from this too. And one last point on Bingham, the inconsistencies, when he actually brought up this idea that, well, the Bill of Rights are already incorporated. He was actually shut down in the debate on that. What are you saying? You're crazy. We've never thought that. Nobody has ever said this before. Oh, yeah, it's already there. It's already incorporated. We got the Constitution. The Supremacy Clause already did this. What? That's crazy. This was brought up in the debates in the 39th Congress. So this whole notion that people had thought, well, incorporation is already there. We can find it. As Bill says, he tells the students, find me somewhere. I can guarantee you they go to the Supremacy Clause. And of course, then you just got to point them to the debates and saying, well, that's ridiculous. Nobody ever said that. So this is the point. The idea that somehow incorporation was going back to the founding generation, even Bingham himself, when, of course, Bingham was sick at one point, and then you had the amendment go through the Congress, and then there was some discussion about whether that was really even the intent or not. Berger gets into that and does a nice job with that. And in fact, his follow-up book, The 14th Amendment, which was produced because of the critics, as Jesse points out, 20 years, and Alan talked about that, 20 years, his whole life, looking at this and writing another book, a follow-up book, because this was something that, he was raked over the coals for this. This is, as Alan said, this is a man, he's a Jewish man, a liberal, And he's writing this book that conservatives latch onto. Oh my gosh, he's just done something sacrilegious here. You can't do that. You're a traitor to all of us over here doing all this stuff. You can't do these things, but he's just being honest. And I think that's where we've lost some of the intellectual curiosity. We've all just started, compartmentalizing. Well, this is my opinion. We got to do this on the right or the left or ambulance. We've lost the rule of law and all of that. And that's the important thing to get out of this too. So the rule of law is not supposed to be conservative or liberal. It's supposed to be the rule of law. And if you go back to the Magna Carta, it's supposed to apply equally. And I think, again, that's what we have to do when we think about these issues. So let's get into some of the questions. And that was just my kind of summary of some of the things that were said. And I hope that helped if anybody had any of those kind of questions. But let's see here. Go down to some of the questions. Here's a question. Did any of the Republican 14th Amendment authors some years later begin to express their trepidation about what they had done? Does anybody know? And I'm trying to think on the top of my head where they said, oh, wait a second here, we might have just opened a Pandora's box. That's going to be dangerous. Does any of the panelists have anything to say about that?
I can't think of anyone who did, but that also may be because the Supreme Court just didn't do that much. So right away, you get the slaughterhouse cases, and equal protection is essentially confined to particular political and legal conceptions of equality, not social equality, which would obviously be transformative. So for the first 30 years, there's just not much being done with the 14th Amendment. I remember being struck when I was a law student. I found this old book on the 14th Amendment with all the cases like leading up to the 1920s. And none of the cases that I was learning about in law school were there because the 14th Amendment just didn't do that much to the nation other than, in that libertarian sphere dealing with Lochner. There really aren't that many cases. It just wasn't that big of a deal really until the 1940s.
Yeah, we didn't mention the slaughterhouse cases. Do any of y'all want to talk about that just for a minute? Because this is often brought up. The slaughterhouse case is really the first time that we saw any kind of reference to the 14th Amendment in a way that would be, as a landmark case. So, Jesse, if you want to do it, or Bill or Alan, I don't care. If you all want to chime in on this, the slaughterhouse cases and what they did. It doesn't matter if whoever wants to go.
Yeah, the slaughterhouse cases was 1873, I think. So it's just a few years after. I always forget if it's 71 or 73. But anyway, it's a few years after the ratification of the 14th Amendment, and it's not about the big, controversy at the time, race. It's actually about whether or not New Orleans has the authority to force that people slaughter their animals in this one particular slaughterhouse because of some problems that had arisen within the city with people slaughtering their animals at different places. And the question that arose is whether really all the provisions of the 14th Amendment, equal protection, privileges or immunities, and due process came into play with New Orleans requiring this. And the Supreme Court essentially dismisses all three claims, saying this is absurd. It doesn't create this kind of robust notion that you can do whatever you want. There's no sort of occupational right created here. This is a very narrow right created in the 14th Amendment that has to do with the freedmen. And the most important, lasting legacy of slaughterhouse is that in interpreting all three of those provisions, it limits the privileges or immunities clause, which has to do with the immunities of being a U.S. citizen, to those rights of really moving from state to state. So as opposed to some fundamental right that you may have against a state because you are a U.S. citizen, it has to do with the fact that you are a U.S. citizen and therefore could move from state A to state B. So it's really about interstate rights as opposed to any notion of there being something fundamental inhering in U.S. citizenship. And that, some people say, kind of killed the privileges or immunities clause, and that's why incorporation was pursued under due process 60 years later.
Bill, did you have something to add to that?
I would throw in there too that the slaughterhouse majority, makes clear as much as the decision is vilified today in academic circles, that they start off that hey, the events of the late war and the Reconstruction amendments are fresh in everyone's mind. This shouldn't be hard to figure out here. And they point out that though more power at the center was a desired result of the 14th Amendment, 13th Amendment, 15th, that the framers of the 14th Amendment did not cease to believe in a federal system with the states handling, again, most of the police power type matters that we mentioned earlier. Obviously, now there's a requirement that you have to treat blacks and whites equally under the law, that everyone has access to the courts. Everyone can make contracts. Everyone can come into court and testify. That did not change. And just sort of back to our topic, Berger makes a good point with this, that you've got to remember with the 14th, the whole Reconstruction amendments, but especially the 14th Amendment, that the northern states did not see their world as changing at all because of these amendments. This was, again, Jesse pointed out, the black codes, though, to be honest, to be fair, as I point out to my students that, and I believe Alan talked about negrophobia, the term Berger uses, up in the 1860s, Berger cites 4 or 5 states that when given the opportunity via referendum to give blacks equal vote with whites, nope, not here in the North. We're not going to do that. He points out other features such as, I believe, the Indiana Constitution of 1851. Again, we're talking less than a decade before secession and war. Blacks aren't allowed to enter Indiana. So point being that the northern states didn't believe their world was going to change. What we're doing here with the 14th Amendment is to make those bad Southerners down there let black people come to the courts and testify if they have a contract dispute, let them sell and own property, let them travel around without having to have a pass or be declared a vagabond. And I think when you look at it in that context as well, I mean, that's another big point Berger raises, is why, as Jesse said, the 14th Amendment was limited to these matters in the Civil Rights Act of 1866. Whereas in the North, this thing was sold and billed as, this isn't going to change our world at all unless we all of a sudden stroke out and become like those horrible people in the South. Our life's going to go on as normal. This is to deal with these problems in the South that Jesse talked about, which is, again, another reason that everybody really understood this was a limited interpretation. And the Slaughterhouse Majority makes that pretty clear, that this was to protect the freedmen, right? Not the butchers of New Orleans or any other corporate entity or business. It was limited. And Berger also points out that, some of the great lawyers of this time were in Congress, like Senator Johnson from Maryland, who was, when you look at hiring an advocate to go before the Supreme Court or any other court, he was sort of like the Daniel Webster of his time. And he never tried to trot out provisions of the 14th Amendment to help some of his big corporate clients. And so Berger says, why do you think he didn't do that? Because he knew the limited scope and to whom the 14th Amendment really applied.
Brian, a couple of points on the question about Slaughterhouse.
Sure, yeah.
First is that the justices in Slaughterhouse are obviously much closer in proximity to the ratification of the amendment than we are today. Now, that fact alone is not dispositive in any way. I can think of, for example, the way Justice Roberts ruled on the Obamacare and how he interpreted that as a tax. And I wouldn't want to say, well, because he, imagine 150 years from now, we say, well, Robert, since he was closer to the time period, had it right. So I'm not saying that that's necessarily dispositive, but it's an interesting point to make. The other thing is for the people advocating for a revival of privileges or immunities after the clause became, as I called it earlier, dead letter after Slaughterhouse, is that I suspect, and obviously this is just hypothetical, that judges could have created a list out of substantive due process, out of privileges or immunities, just as they did out of substantive due process. You could have we have this entire body of jurisprudence emanating from a footnote in one case in 1938, the Caroline Products case. So like what would have stopped the justices from figuring out some weird way of getting to the desired result through privileges or immunities, since the vehicle that was used was a footnote in a case? Like it's not hard to imagine the interpretive acrobatics that could have been done to get to that intended result. Justice Thomas has been mentioned, is mentioned that he's in favor of reviving privileges or immunities, or at least being open to considering that. And he's recently written that he's ready to reconsider the entire substantive due process line of cases, which is a very interesting dicta in one of his recent special writings. But that solution, both, if just switching privileges and immunities for substantive due process, to me, still gets at a problem with the judiciary, giving unelected judges too much latitude to enact policy preferences and constitutional law. You still have the potential for that problem. Now, you, as Jesse mentioned, you now have the predominant mode of interpretation as originalism, and that's sort of across political aisles. At least certain justices on the left pay lip service to originalism as a legitimate, if not the preferred method of judges. So there is a limiting principle, more limiting than the one that existed, during the Warren Court, just for example. But I still see long-term problems with even the revival of privileges or immunities.
Yeah, one thing that wasn't pointed out with the 14th Amendment too, and after it was ratified supposedly, is that in D.C., which of course the Congress controlled, there were still segregated schools in D.C. for years. So if this was the intent of the amendment, well, that wouldn't have happened. I mean, Congress would have done something about that. So you still had these issues going on beyond. People just didn't think it really applied to these things. As Bill points out, this applies to these Southerners down there to clean up their act. We got to go in and clean up the South and make sure that Republicans win. I mean, that you look at what they were trying to do with all of this. We've got a real problem with voting happening here. We got all these, and I think, and Alan pointed that too. We have all these people coming in that are going to now vote. We got to do something about that, because we're going to lose elections if we don't take care of this problem. So there were some real tangible things that were going to happen. They could see on the horizon very quickly if they didn't make some changes that they were going to lose their political power, and that's something that they had to address. So again, the limited nature of the 14th Amendment has to be emphasized in 1868 or 1870 or 72 whenever we're talking about that Reconstruction period. It certainly was part of that. Jesse, did you want to add something else that you...
Yeah, just on that point, the DC school problem, that inconvenient fact, it really drove the move from original intent. Because, as you said, you can't infer an original intent to desegregate the schools if the same Congress at the very same time provides for segregated schools in DC. So Michael McConnell, a law professor, wrote an article in 1995, part of this movement that I was talking about, away from original intent toward original public meaning, whereby he ignores, okay, this is what Congress must have intended given the segregated schools, and moves toward that public meaning. Well, what does equal protection mean more as an abstract matter?
Yeah, I mean, you got to figure out a way to do it, right? I mean, so if we want to get an outcome, we have to come up with a way to do it based on, well, we could say it's kind of like this. I mean, it works, right? So this is how we have to attack these things. Alan, this is actually maybe a question for you because you are the Oliver Wendell Holmes scholar. I know you wrote a chapter in one of our books on one of our Abbeville books on Holmes, and but there's a quote here. As I recall, Wendell Holmes had a quote about the changing nature of the document. Is there something about that? Or are there any quick reads that can show his views on the 14th Amendment? Wendell Holmes, does he have anything out there that you're aware of on the 14th Amendment?
Sorry. Yes, quickly. He does. I don't have the citation for you, but I've got it in my own book back behind me. I can go flip through it and get you the citation in a moment. But he actually was not a fan of expansive interpretation of the 14th Amendment. And Holmes Holmes is cited favorably by Berger. He is sort of a man of judicial restraint and deference to state legislatures and deference to legislatures just generally. I think what people mistake about Holmes, a lot of people look at Holmes and they see his language about the common law, and they hear this language that sounds evolutionary and talks about emergent orders and laws changing according to circumstances. And what Holmes is a scholar of common law. He's more of a historian, and he's looking at the development of the common law over centuries. And that's what he's referring to. He's not referring to what the U.S. Constitution does. And even Holmes, I'm not sure, developed a very robust jurisprudence, a very consistent, robust jurisprudence. He's not systematic in the sense where he's saying, I'm going to set out to establish originalism, and this is how it works, and this is the formula for how you interpret statutes, and this is a canon of statutory construction, or anything like that. It's a very transitional period in Supreme Court history. I mean, he serves a long time, first of all, as a judge, first in the Massachusetts Supreme Judicial Court, the highest court of Massachusetts, and then on the U.S. Supreme Court. So you have to read a lot of what Holmes is saying in context of what he's reading philosophically. He's reading the Pragmatists, he's reading C.S. Peirce, he's reading William James, he's reading Nietzsche and all kinds of novelists, and he's an intellectually curious person. And I don't think that there's a whole lot of system building to his thinking. I would say that if there's anything that he stands for, it would be restraint, in the sense that he is going to defer to legislators. He's going to try to defer to states whenever possible. And the one exception to that being late in his career on First Amendment issues, when he sort of took the collision of ideas approach and favored free expression. But let me pull my own book from off the counter and come back to you on the Holmes quote.
Sure. Yeah. We'll go to actually, there's a book that was asked for Jesse. When you talked about Bingham, what was the new book on Bingham that's out now? Somebody asked about the actual title of that book. You're muted.
Yeah. American Founding Son, John Bingham and the Invention of the 14th Amendment by Gerard Maglioka. It's not that new. It was written, I think, in 2016.
Yeah, I think I remember seeing that in Barnes & Noble even at the time. It was around. It was some people. It was fairly popular a little. So when I say new, I'm a historian, so new can be 10 years. I mean, that's still relatively new. It's a new book.
Right.
But
the chapter on Bingham and the 14th Amendment, so the whole entire book's on Bingham himself, but there's a chapter on the 14th Amendment. Probably the most astonishing thing that you'll find is that he was saying that Article 4 had already incorporated the Bill of Rights. I think, Brian, you had mentioned that, which is obviously crazy. Just look at the text of Article 4 and the Privileges and Immunities Clause. And given that Barron v. Baltimore was widely accepted by, none other than Chief Justice John Marshall, who wrote it. So it's a strange position. And he says, well, we don't need the Privileges or Immunities Clause in the 14th Amendment because we have the Privileges and Immunities Clause. They mean the same thing, but we should adopt it anyway. He's just all over the place. So the book does a good job of capturing that.
Brian, this is Holmes in his dissent in Baldwin v. Missouri. He says, I have not yet adequately expressed the more than anxiety that I feel at the ever increasing scope given the 14th Amendment in cutting down what I believe to be the constitutional rights of the states. As the decisions now stand, I see hardly any limit but the sky to the invalidating of those rights if they happen to strike a majority of this court as for any reason undesirable. I cannot believe that the amendment was intended to give us carte blanche to embody our economic or moral beliefs in its prohibitions. Yet I can think of no narrower reason that seems to me to justify the present and the earlier decisions to which I have referred. Of course, the words due process of law, if taken in their literal meaning, have no application to this case. And while it is too late to deny that they have been given a much more extended and artificial signification, still we ought to remember the great caution shown by the Constitution in limiting the power of the states, and should be slow to construe the clause in the 14th Amendment as committing to the court, with no guide but the court's own discretion, the validity of whatever laws the state may pass.
Yeah, thanks. That was great. So Holmes, as you said, he's seen as this kind of progressive, he's going to be on the cutting edge and expanding federal power. But this is why it's great to have you on, because your work has actually shown the exact opposite, that Holmes wasn't necessarily interested in that. He was concerned more about maintaining a federal character. But that chapter in Northern Opposition, Mr. Lincoln's War, is good too, because it's Holmes there's some really good stuff in that chapter. I won't spoil it, but there's some really good stuff.
Almost everybody hates Holmes, and so everybody wants to put him in some kind of box. He really has no defenders and no champions. He did. He was very popular mid-20th century, but he has no defenders and no champions anymore. And I think people always try to use him as somebody that stands for this, that, or the other thing. And that they're usually wrong, because Holmes didn't really stand for anything.
Yeah, Ken Burns likes Oliver Wendell Holmes. You had him in several of his documentaries. He cites him. So anyways, it's he's an interesting character. Bill, I actually wanted to ask you a question. You brought up Bushrod Washington, and because you did a nice job with that when you were presenting, can you explain a little bit of that Bushrod Washington situation? Because it is very funny. Bushrod Washington is related to George Washington, by the way. So you have this, he's got the last name Washington. He makes this statement on what these things are, this kind of rumination about these privileges and immunities. And it's getting to all kinds, he goes off and lists all kinds of things. It's a long paragraph of stuff that he thinks we should have. And in fact, the Randy Barnett and Evan Bernick book, The Original Meaning of the 14th Amendment, uses Bushrod Washington as part of the basis of their argument. Well, this is what people really meant, and this is what was really meant by the founding generation, or at least in that period of time, when it comes to privileges and immunities. So can you get into that just a little bit for a minute?
Sure, I'll be happy to. Of course, it was as I mentioned, it's a fairly simple issue that he's presented with. He's a Supreme Court justice, but he's riding circuit, so he's deciding a decision alone. This is not the full court, and it's fairly simple issue. Does the Privileges and Immunities Clause of Article 4, which we've talked about here, allow an out-of-state citizen to come in? I believe it was New Jersey, I could be wrong, either New Jersey or Maryland, to come in and dig oysters in that and that state's waters. Essentially, almost the same question is, I'm a South Carolinian. Can I just grab my rifle and go over to North Carolina and hunt? Can I hunt their deer in North Carolina? Can I dig, another state's oysters? And the ultimate answer he comes to is, no, you can't do that. The state can regulate that, and has an interest in keeping out-of-staters from doing so. That's the holding. But in getting there, he gives us a lot of dicta. That is, legally statements that aren't necessary to the ultimate decision of the case. And that's where he starts to wax eloquently on, well, what do privileges and immunities mean? And launches off, as you mentioned, into this long list, some of which no one would think was a privilege and immunity. For example, voting, I used earlier. No one then or even now believes that again, I can just cross the border to North Carolina and say, hey, I'm here to vote today in this election that you're having for a representative or a mayor or whatnot. No, it doesn't apply to that. But, he includes some things that clearly no one would have believed were privileges, immunities, rights. Kurt Lash defines privileges and immunities where, for example, Justice Thomas, in making his argument, says, what does privilege and immunity mean? It means right. That's when we talk about rights. They talked about privileges and immunities, and Kurt Lash has done some good work looking at how that term was used in early charters and otherwise. Say, no, it's really not what we would call a right. It's essentially certain privileges granted by official grace, is how he describes it. And again, hunting and other things like that you could give as an example. But to get to your point, you are correct that, and it's in the debates in the 39th Congress, some point to his lofty language, Washington's that is, on what privileges and immunities mean, to say, see, this is it. And then historians say, well, yep, Corfield, that case tells us what privileges and immunities meant historically, when again, it is an outlier. I mean, it's truly an outlier. If you look at state, for example, Samuel Chase, before he was on the United States Supreme Court, examined this language in a Maryland decision and was nowhere near what Washington, again, viewed it very narrowly. Hey, you can't discriminate against out-of-staters and certain matters that things have been granted by the state. So everybody has latched on because they've got something in print. They've got a Washington, the name attached to it, and they use that to support it. But it's dicta. It's an outlier decision, and you have to concede that many of these fundamental privileges and immunities that he lists, at least, for example, with voting, nobody would have characterized voting that way. So it's a much abused decision there that the incorporationists throw about.
Right. I mean, if voting was the case, we wouldn't have had the 15th Amendment. There would have been no need for it. I mean, this is the point. Or the 19th Amendment. There would have been no need for these things if voting was part of a privilege and immunity. So it's, and actually somebody brought up in the chat the Blaine Amendment, which would have required, it shows that they didn't really think that the 14th Amendment incorporated the First Amendment, because the Blaine Amendment would have actually kind of done that. I mean, that was the point with schooling and public education and private religious schooling. So at the time, even James G. Blaine of Maine, I love it, Blaine of Maine, who was actually a candidate for president against Grover Cleveland, thought that this thing didn't incorporate anything. We still have to have this new amendment, which would kind of do that. So they certainly had an entirely different perspective on incorporation in the Reconstruction period than we have now. So that was interesting. Let's see here. Going through the questions, we only have about 10 minutes left, but is there any difference between substantive due process and the invention of new rights? It's kind of a broad, open-ended question. Or do they mean the same thing, or can they mean the same thing? So substantive due process and invention of new rights. Anybody can answer.
I'd say substantive due process is the primary vehicle used today to recognize new rights, but but there are others. Randy Barnett, since we've mentioned him, would point to the 9th Amendment, and others would say, well, you don't, the substantive due process, abortion, maybe that is crazy, but we need to look at the 9th Amendment, and that's one of the rights retained by the people, rather than seeing the 9th Amendment as a rule of construction. So quickly, the answer is the two do kind of run hand in hand, substantive due process and creating unenumerated rights by the court, but there are other vehicles that those inclined to do so would use, the ninth being one, and other matters. And sorry, I spoke over someone when I started. I apologize.
No, that's fine. I was just going to say that not all rights, of course, come from the Supreme Court. One of the most important rights laws we have, inventing new rights, the Civil Rights Act of 1964. Then you have rights created in Title II, applicable to public accommodations, rights created in Title VII, applicable to private employers. So we shouldn't think of rights only as applied to governments and created through constitutional interpretation, but statutes can create rights as well.
I don't know if y'all can answer this question. I can pitch into here, but the question is, the state legislature's debates over ratification are relevant to original intent. I mean, this is when we talk about original intent, we look at what the Constitution meant at the time it was ratified. This was one of the important parts of it. Do they contain any discussion of incorporation? So I don't know if anybody's familiar. I mean, I can answer this question, but I'll let you all go first. If anybody has an answer to this, or I can do it, but anybody want to chime in, or they say, no, I'm not tackling, I'm not going to do that.
Go for it, Brian.
Bill, did you want to say, it looked like you were going to say something.
No, I think Berger does mention this briefly in his volume. And of course, you've got to remember that Southern states, they're just under duress. It's kind of take it or leave it there. And I think Berger would argue again that and he points out in his book that the speeches made in favor of the 14th Amendment out on the trail, prior to the conventions and such in the North, or legislatures, again, the argument was, hey, this isn't going to change us one iota. It's fixing the problem below the Mason-Dixon line. So that's kind of what Berger points out, but I'm happy for you to elucidate further, Brian.
No, I think that's what I was going to say. I mean, there at the time and during Reconstruction, we have to understand the immediate political pressing problem, which was, how do you bring these states back in the Union and make it to where Republicans can have ascendancy in those states? And to do that, you're going to have to ensure that the 3.5 million people, or the voting age population, male voting age population, eventually in those states, is able to have some kind of political power. And you're going to disfranchise, because I mean, that's also the key of the 14th Amendment. There is that part where you take and you disfranchise a large number of Southerners, white Southerners, and you say they can no longer vote. So what you have done is created a permanent, in their mind, at least for a time, a permanent political majority of Republicans. And we can't forget that. I mean, there was a certain political aspect to the 14th Amendment, which is why some of the states got a little cold feet on this thing. Well, what are we doing here? We're going to create a situation that's going to be dangerous long term, because we're now getting involved in areas that the Congress has never really discussed before. And even when you get to the 15th Amendment and you have the debates on that, and I know we're still dealing with this period of time, Thomas Bayard of Delaware, who later would serve as Secretary of State, ambassador to Great Britain. I mean, he was actually arrested during the war for having a militia company in Delaware. His father is James Bayard, who was a senator at the time, resigned his seat in 1864 after he took the ironclad oath of allegiance. He said, this is ridiculous. I'm not going to sit here with these reptiles. That's what he called Republicans, these reptiles. But Thomas Francis Bayard gives this long speech against the 15th Amendment when he says, we're getting into areas now that are completely under the control of the states. We're going beyond anything the founding generation ever wanted this government to do. And that's what people thought about the 14th Amendment and expanding powers that maybe the Congress really didn't have. And so that's, again, when people got cold feet, that was the issue. It was, they could see the political nature of the amendment. They could understand what was happening here with this thing. And when you think about the state ratification conventions or the state legislatures that ratified it, there was some discussion about this in some of the Democratic states. And this is why they rescinded the ratification. This was not, you were not going to tell a state that wasn't a state that had to ratify an amendment. That's illegal, number one. And then number two, you had the other political motivation for it. So Bill, did you want to add something else?
Yeah, just along with this, I mentioned this just briefly in my opening statement. Whereas again, we're talking about Section 1 of the 14th Amendment. And in our time, this is the end all and be all of the 14th Amendment. To those living at the time, Section 2, which talked about apportionment of representatives there, Section 3, which disqualified Confederates who had previously taken an oath of allegiance, and then Section 4, which prohibited the Southern states from recognizing their debts as valid when they were fighting the Union. Those were more of the big ticket items there. What are we going to do if all these Confederates come back into the Union and start voting Democratic and we're in the minority all of a sudden? Well, Section 2 deals with that problem on if states, depending on how they treat their Black population, which Congress assumes, again, not definitely some, for good motives, want the states to grant Blacks the right to vote as to move them along the path of full citizenship, but also a whole lot more, as you mentioned, Brian, it's more like, well, we just want them to vote Republican. We just want the ascendancy of the Republican Party. And then again, Section 3, this whole thing we talked about with Trump, insurrectionists. Well, this is how we can keep Alexander Stephens and others from coming back to Washington and making law quickly. And then the whole public debt thing. So I think when we look at original intent, yeah, Section 1 was a part of it, and it was understood narrowly, as I think we all agree, in relation to the Civil Rights Act of 1866. So while we're having this whole big discussion today on Section 1, you go back to the late 1860s and the talking heads of the time and the congressmen and others, they're talking about these other provisions that we pretty much ignore nowadays, because that was what was front and center in their world.
Yeah, one thing we forget when you brought up the Trump situation, we're running out of time, but Alexander H. Stephens actually was reelected. I mean, these people showed up to Congress, and Congress has the right to seat or not seat people. So they didn't seat them, but they had to come up with a way to keep this from happening again. I mean, this is what they wanted to do, because they didn't want these former Confederate leaders, many of them who are prominent men of the communities. I mean, when they're going to elect people, this is who they're going to pick. And they don't want them coming back in. They have to keep rejecting these seats when they keep coming into Congress. So no, you can't sit here. You can't sit. They wanted to stop that, nip it in the bud, and that was it. So the practical problems of 1868 and 1869, 1870 were in the heart of what's called military Reconstruction. I mean, these are the things that are going on that they have to address in their mind. And of course, the Civil Rights Act of 66, which would get them, get freedmen some, again, these rights that white Southerners also had that they didn't want to deny. So the very limited scope of it. Now, we're right up at the time here. Does anybody else have anyone want to have any closing arguments or anything closing to say for our conversation? This has been a lot of fun. We can start with Alan. Anything you want to say to wrap up, or?
No, nothing substantive other than thank you for putting this together, Brian.
Bill, how about you?
No, I had a good time, and I've learned something from just listening to each of you. So I'm appreciative.
And Jesse?
I also want to thank everyone. I learned a lot, and recommend that all of the viewers, listeners, read that Forrest McDonald article, because he goes through the entire history. I assign it to my students, and something I don't think we emphasize enough, in that Reconstruction Act of 1867, the 10 states are carved up, turned into 5 military districts, and then they have new rules about who can vote for the 14th Amendment. I mean, that's a big part of the story. And then the vote is overwhelmingly in favor of the 14th Amendment because it includes only those men who had not fought for the Confederacy, meaning really only the Black population. So the percentage in favor of the 14th Amendment is off the charts. And I think that's covered in the article as well.
Yeah, it's a really good article. We have it on the Abbeville Institute website, so go out there and check it out. Forrest McDonald, it's the 14th Amendment. Somebody linked to it in the chat, but it's I can't remember the title off the top of my head, but it's a really good article. So this is going to wrap it up. This will be on YouTube if you want to catch it later, or if you somebody needs to see this. It'll be on YouTube on the Abbeville Institute channel, so go and check that out. There was a question about our 1607 project book. We're still putting the finishing touches on that, so that'll be out probably the end of March or early April as we finish that up. But we do appreciate all of our panelists for coming out today, and then all of the attendees as well. This has been a lot of fun, and we're going to do more of these things in the future, so keep on the lookout for that. But gentlemen, have a very good afternoon and weekend, and thank you for your participation.